Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users getting folks the answer they need from an employment attorney. Today, though, that's not what we're doing. We're playing with a blog post from a law firm in Long Island called Weineck and Famagetti, who I know to be good, honest, and tremendously talented attorneys in our field of employment law. I will post a link to their blog down below in the doobie-doo. I urge you to read the article. It's much more in-depth and extensive than what I'm going to read into the video. Both because, listen, I'm not going to read their article. That'd be wrong. Just read their article in the video. That'd certainly be wrong. So you should go look at the video or go look at the article. But also, I'm giving a shortened, summarized, and bastardized version of what they wrote about here to simplify it. Not calling my viewers folks who need simplified things provided to them, but I don't think everybody needs all the complexity that they provided in their really, really wonderful blog post. So, and also if you want the case law, I think all the citations are in their blog post, so you can go get the case law there. I'm not going to give it to you. Now, we have a case here where and I'm calling people defendants and plaintiffs. That is not what they are, because this case pended through the New York State Division of Human Rights. They're actually going to be complainants and respondents. But to keep everything kind of normal for the channel, we're just going to call people plaintiffs. The plaintiff here is the complainant, the person who complains, and the defendant is the respondent, the person who responds to the complaint. Now, there was a housing discrimination case that was brought in the New York State Division of Human Rights, and the plaintiff, somebody who was, I guess, seeking housing and felt they had been discriminated against, sued, brought a claim, brought administrative action against this entity, the defendant, because they felt they had been the victim of discrimination in the process of, obtaining housing, probably renting. Now, they lost. They lost that claim. But, strangely, the defendant turned around after the plaintiff lost their claim and sent a letter to the plaintiff, among other people, there's other parties here too, threatening to sue for libel, slander, things of that nature. And I'm being very general here. Now, in response to that letter, the plaintiff, who received the letter, threatening to sue them, goes back to the New York State Division of Human Rights and brings a claim for retaliation. Now, this goes to public hearing. The claim for retaliation, just the claim for retaliation, goes to public hearing. And the administrative law judge in that hearing makes a couple of findings. There's a lot of complexity here that I won't get into, but essentially finds that the letter threatening to sue the plaintiff in response to their bringing up a claim was retaliation, right? Now, there's a whole bunch of appeals history that goes. They go back and forth on this issue all the way up to the chain. They end up in the Court of Appeals in New York. And the Court of Appeals found, and this is very interesting, such a letter being viewed as retaliatory, such a letter being the basis for a retaliation claim, is a fact-specific determination. And in fact, the test would be that the letter here was found retaliatory to be the basis for a good and viable retaliation claim, because the letter could have dissuaded someone from filing claims of this sort, right? And that's always the key determination in a retaliation claim. Was this something that could have dissuaded someone from filing? Now, this is somewhat in line with a little bit of EEOC guidance on the same issue, right? If you're trying to wield the threat of a lawsuit to keep people from bringing claims against you, generally speaking, the EEOC is not too interested in that, and they can view that as retaliation. Excuse me. And This is important because one of the main fears of plaintiffs in our field is always, well, can I be sued in response for bringing my claims? And in a lot of jurisdictions, the answer is always yes. You can always be sued. We live in the United States. You can be sued at any time by anyone for anything. You can, even if you've never interacted with them. Doesn't mean the case is going to be viable, right? But the case doesn't always have to be viable because the expense of defending the case can be as onerous to the plaintiff as anything else, as losing the case would be. Now, generally that doesn't happen. I can count the times I've seen that happen in my career on one hand. It's not a realistic fear, but it is a fear, right? And that's out of hundreds of cases. Like, take into account, if we're running 450 cases a year, and over the course of my entire career, I've seen it happen less than 5 times, you're in good company in terms of saying, hey, it's not that realistic of a fear that I'm going to run into this countersuit issue. Now, that being said, this finding and the EEOC guidance on the same topic give the plaintiff some teeth, right? Like, now it's not just, hey, that's probably not going to happen. And it's not just, hey, the jurisdiction we're in has a lot of protections against slander and libel lawsuits and defamation lawsuits, where the slander, libel, or defamation is taking place in a filed complaint, right? That's a huge protection because a lot of times, in many jurisdictions, if you file a complaint, it generally can't be the basis, or at least there'll be some protections against it being the basis of a defamation claim. Those are both great. But here, if they're coming after you for this hypothetical, we're going to sue you for defamation for bringing a claim against us, you then, as a plaintiff, can just say, hey, my complaint was in good faith. And this is retaliation because you're trying to punish me for filing a good faith complaint. And it's very important now, the New York State Human Rights Law, the New York State Division of Human Rights, you're going to have this case law, this finding, and it's a housing discrimination case, but it's still applicable. Like, you can port over a lot of the decisions here to the field of employment law, which is very similar, and in New York State is dealt with by the same law, the New York State Human Rights Law. And you can say, oh, so you may have sued me for this defamation claim, not because you thought you would win, but because you want to drive up my legal fees. But now you've handed me an additional claim against you, and that additional claim against you is lower risk and potentially higher value than the claim you brought against me, right? This is important. This is in many ways arming the plaintiff in this scenario to go back at their tormentor, right? Like, the group that discriminated against them, that they made a complaint against, is now trying to attack them for having the gall, the chutzpah, to make a complaint, right? Can't have that, because then the system won't work. So as long as it's a good faith complaint, when this group comes at the plaintiff for making the complaint, they have this retaliation claim. And it's fact specific, right? Like, you have to actually believe that it would keep people, like, if somebody's just like walking out of court and like, I ought to sue you for defamation. I don't know what that accent is, but like, maybe that wouldn't do it, right? Because you're saying I ought to, and you probably aren't gonna. That's probably not enough, maybe, to keep someone from filing a complaint of discrimination in the future. It might be. Listen, I don't know what the court's gonna find, but it might not be. Here, the letter was like an attorney letter, and it seemed pretty official, and it appeared to say they were pursuing very real claims, and it was very clearly an attempt to scare the plaintiff. Right? At that point, it's a pretty clear effort to dissuade someone from filing discrimination claims in the future. Certainly would qualify as retaliation, and it's really valuable to arm plaintiffs with that. So, takeaway here is Weineck and Famagetti, fantastic, so great. Everything I've ever heard about them, great. I know Mr. Matthew Weineck somewhat. Generally good terms, and I think he is swell. I think I've met Mr. Famigetti maybe like once or twice. Like, generally I've heard good things. We have many mutual friends in common. And unlike many firms in Long Island, I've never heard a bad word said about them. So, my hat's off to them. Remember your local counsel. Always a good option, right? And especially if you happen to be in Suffolk or Nassau County in Long Island, great option. But also, this work that they're doing is tremendous. Helps so many people. The blog is wonderful. Highly recommend. I'd say that's probably all we got for today. Like, subscribe, comment down below. Helps the channel to grow. Take care.